Please be seated. We're ready for argument in 23-1028 in the matter of J.J.T.
Ms. Stryker and Mr. Nielsen will present argument for the petitioner. Petitioner is reserved 5 minutes for rebuttal. Ms. Stryker will open with the first 9 minutes and will present the rebuttal.
Thank you, Mr. Chief Justice. May it please the Court. Again, for the record, my name is Melissa Stryker, and I'm here on behalf of the Harris County District Attorney's Office, representing the state of Texas in this case, along with Mr. Aaron Nielsen, the Solicitor General for the state of Texas. We are here today because the state submits that the First Court of Appeals erred in this instance by misconstruing Section 54.02J of the Texas Family Code in two critical ways. First, the state submits that the First Court of Appeals erroneously collapsed the alternative standards or bases for transfer of a juvenile offender that are provided by subsections A and B into one standard, and in doing so, improperly grafted a probable cause requirement that is contained in subsection B onto subsection A. The reason that this error matters is threefold. First, it's a blatant example of improper statutory construction.
Well, it comes from the trial court order, right? And the trial court order mashes these things together. Is it just a form that the courts are using that has this sort of Frankenstein standard in it?
I would have to be speaking beyond the record, but yes, the juvenile courts often use forms and repeat the same and change out cause numbers, dates, and names of parties interchangeably, but it is commonplace for juvenile courts, I would believe, not just in Harris County, but across the state, to use both subsections A and B together in their transfer orders. And the way that the statutes are written and the statutory history of these statutes would indicate that those statutes are meant to be used not only as alternative bases to support transfer, but they're meant to work together to cover a panoply of situations wherein certification of a juvenile offender might be appropriate.
But the only one that is in the order in full is A, and so that's the one you're relying on?
Yes, Your Honor. Unfortunately, whether it was due to a typographical error or some other mistake, the words due diligence are not contained in the trial court's order in this instance, which precludes subsection B from being a basis for justifiable transfer here, regardless of what the record might show. So yes, the state is relying on subsection A entirely to establish that transfer was appropriate in this instance.
Say that we agree with you, that the trial court erred in collapsing the standards, and the Court of Appeals kind of carried forward that error in its analysis. What is the evidence that was beyond the state's control to obtain during the year before J.J.T. turned 18? So the state has the burden to show that it was beyond the state's control. What is the evidence that was beyond its control to obtain?
Your Honor, the evidence would be anything that ties the respondent in this case firmly to this murder. So the way that
right. So you have a accomplice who has said J.J.T. Is culpable for this murder, and you know, I understand that the state wouldn't want to go forward just with that accomplice witness testimony, and whether that's enough for probable cause or not. That you'd want some independent corroboration. But what roadblock or something outside the control of the state happened during that year to preclude the state from obtaining that information?
Well, a few things, Your Honor. First of all, the state didn't have any other evidence. They didn't have any physical evidence.
The state didn't. What efforts did the state make to obtain that evidence in that year? Like, for example, if they had subpoenaed the records during that year, is there testimony that they couldn't have gotten the records in time? Or if they had tried to find the cell phone number of J.J.T. during that year, but they couldn't. There's no, what evidence is there from the investigator that here we tried these things and for reasons beyond our control, they were unsuccessful?
Deputy Crane testified as to the steps of his investigation, and he described that they essentially came to an impasse. you have the initial statement by the accomplice witness, and the majority opinion in this case uses the accomplice witness statement as what they consider to be the foundation for probable cause in this instance. And the state would disagree with that here when you break down what an accomplice statement is and the import that it has. Tovar's initial statement here was
Right. Say that's all, that the state wouldn't want to go forward only with accomplice witness testimony. So the question then is, because under Moore from the Court of Criminal Appeals, investigative preferences are not reasons beyond the control of the state. So a preference for investigating after the person becomes an adult is not a reason. So what is the reason that they were unable to obtain corroborating evidence?
Well, for example, the state was not able to obtain J.J.T's cell phone records, either to actually search his cell phone or to obtain his cell site location information, because the state lacked probable cause to obtain a warrant for those.
Okay, so is there testimony that they attempted to get a warrant for the location, cell phone warrant? Not the interior contents of the cell phone, but just to establish that J.J.T was at the location of the murder. Is there evidence that was turned down, that was requested and turned down, or?
There isn't evidence that he...
Or even that in the investigator's experience, if they had sought such a warrant, it would have been turned down.
There isn't evidence in the record that it was turned down, but there is evidence from Deputy Crane that he did not have probable cause at that time to obtain a warrant, or to either an arrest warrant for J.J.T at that time or a cell phone warrant, because he lacked
it says that about the cell phone warrant?
He's asked, and I believe during his cross-examination, he's asked about what he did during the interim between Tovar's initial proffer statement and when you have this, I'm sorry, not the proffer statement, his initial statement upon arrest, this is the accomplice, and his proffer statement, which occurred in December. And during his explanation of what he was doing at that time, he was waiting for some forensic analysis to come in, which he hadn't obtained yet, and he described that he lacked probable cause to go forward. So there isn't...
Yes, with an arrest, but the point of this is, what about any of it was beyond the control of the state?
Well, you have an implied finding by the juvenile court in this instance when you take together all of Deputy Crane's testimony.
Right, and I think the finding is there. It's not even implied. He says for reasons beyond the control of the state. But what is the basis? What is the factual basis for that finding?
The factual basis is all of the facts that Deputy Crane testifies in his steps to investigate this, and then reaches an impasse prior to Tovar reinitiating contact with the police and providing additional information that the state could then use as probable cause to substantiate a warrant.
So if we were to reverse this case, what would stop the state from simply waiting in any case involving a juvenile until the juvenile turned 18, instead of going through the discretionary transfer procedure that we have for these sorts of crimes, where there have to be really specific findings made with respect to the juvenile to be tried as an adult? So what would keep the state from simply saying, well, I'll just wait until the alleged offender turns 18 to bring the charges, and then we don't have to go through any of that transfer proceeding. We just automatically get to proceed with the offender as an adult?
Both of these subsections A and B, as well as the jurisprudence of the state, including Moore, which Your Honor would certainly be familiar with from the underlying opinion before the Court of Criminal Appeals affirmed that. Those statutes and that jurisprudence operate as guardrails, as well as the trial court's function here as a gatekeeper, interpreting the evidence and testimony that it receives and deciding whether that amounts to either a reason beyond the state's control to not proceed under subsection A, or makes it the assessment that probable cause didn't exist prior to the respondent's 18th birthday, but then probable cause was developed afterwards.
Right, and you can see that very easily, like, for example, in a case where the outcry doesn't come until after the juvenile's 18. So, you know, something happened, some violent crime happened while the alleged offender was a juvenile. And then, but no witness came forward. No one approached police about the crime until after, you know, the 18th birthday of the juvenile. And that seems to be what the statute is getting at. But what about this case where the juvenile was implicated almost immediately so there was time. And why, you know, that's why this reasons beyond the control of the state is doing some work.
So I would disagree with your characterization about the accomplice witness statement as it first arose. And I think it's an important distinction to make here. So accomplice...
Well, the murder happened in October, and November 12th, the police arrest the accomplice Tovar, and he identifies J.J.T. as the shooter within a month.
Yes, ma'am. But the nature of that accomplice witness statement matters because accomplice witness statements are categorized in 3 different ways. So in Walters v. State, which is a Court of Criminal Appeals case from 2008, the Court of Criminal Appeals divides accomplice witness statements and basically weighs them in terms of what they're useful for. So the first classification of an accomplice witness statement would be one wherein the accomplice accepts blame, says I'm guilty in some way of this offense. The second one, which is a sort of middle ground, is a blame sharing statement where it says, you know, Joe and I committed this murder together and we're both responsible for this criminally. The third type of statement is an entirely blame shifting statement where they say, hey, I was merely present as the accomplice, but I had no part of this murder, and I can't be held responsible for it. The third type of statement, a purely self-serving blame-shifting statement, is not as weighty in terms of what it comes to bear as far as how it's held to be credible. Its uses as a statement against penal interest, because again, a statement against penal interest requires that the speaker be liable in some criminal way based on the nature of that response. So a purely blame-shifting statement, especially here where mere presence alone is not a crime, doesn't serve as a basis for probable cause. It doesn't have the indicia of reliability that the first 2 classifications of an accomplice witness statement would have. And all that Tovar, the accomplice in this case, gave at the November 12, 2020 meeting with police when he was arrested was a purely blame-shifting, self-serving statement. So it did not have the indicia of reliability that was necessary for that statement to carry weight. So
Is that the statement that the Court of Appeals says implicating Jacob was against Tovar's interest because he admitted he was present with Jacob during the shooting?
yes, Your Honor.
And do you agree with that statement?
I do not. I believe that Tovar's initial accomplice witness statement was in that third category, which is the weakest of statements that an accomplice witness can give, and that it had no, as I say, indicia of reliability for either. Crane clearly didn't believe it because he was very reticent to move forward with just that and proceed for quite a while. Even after Tovar added to that statement in December, still needed more from that to move forward.
It does acknowledge that he was present there, so in that sense it's against his interest, but is it the point that he would say that because there was fingerprints and all this kind of stuff there?
Perhaps, but mere presence is not a crime. So he could have been present all day long, and if he took no part in participating in planning the murder, executing the murder, assisting J.J.T. after the murder, such as by disposing of the weapon or some other way.
No presence mere presence may not be a crime, but presence as opposed to non-presence is obviously not great. So in that sense, is it not against his interest?
Not according to the law of the state. So to be against his penal interest, it would need to admit some sort of criminal culpability. And mere presence alone, which is all he admits to, doesn't get there.
So maybe not in the formal sense, penal interest, but at least in the sense of his risk of saying, well, yes, I was there, I saw this happening, increases the odds. Like, well, now we've got him at the scene, as opposed to if he could just deny even being, well, I don't know, I was not even there, how would I know? Clearly, in a common sense level, it's against his interest. But my understanding was that it would, your view of this as being something that was self-serving is because, well, they had objective evidence that he was there. They didn't need him to say that, and that's why it becomes a shifting thing that's not particularly against his interest, whether it's formally or informally. Am I understanding the state's position on that correctly?
Yes, Your Honor, and I believe that the evidence that the state had otherwise, aside from his statement, his fingerprints alone also did not do anything more than establish mere presence.
Any,
Yeah.
Justice Lemon.
So this all strikes me as there's a lot of second guessing going on at this time. And so you have the prosecutor's discretion to decide when to do this, when to do that. And so when you have that thing that you're looking at as a court reviewing the matter, and then you have the other thing that Justice Bland brought up that, you know, what's going to keep people from just sitting back and waiting until they turn 18 and then no problem. How would you suggest that we balance those two?
Well, Your Honor, I think as I mentioned in response to Justice Bland's question, I think the balancing comes natural when these statutes are interpreted as the legislature intended for them to be. So, of course, each of these transfer decisions is going to be a case-by-case determination based on the particular facts in each instance. And I think that this court, by looking at the way in which the First Court of Appeals misconstrued these statutes, both by collapsing the standard and by misconstruing the word practicable in subsection A, that will operate to keep all of this in line. As far as the state's discretion here, that becomes an interesting issue here by virtue of that accomplice witness statement and the state's need for corroboration. So independent of when and if probable cause existed, you still have the state's need for corroboration to actually attain a conviction. And so when those things operate in conjunction as they're meant to, I think the rule flows naturally from that. I don't think the state is asking for this court to craft some special exception for the state. I think the state has an absolute obligation to pursue matters in the juvenile court when it can be done. But when they can't be accomplished reasonably in the juvenile court, that's when transfer is appropriate and these statutes come into play. I see I've exceeded my time, so
Any other questions? Thank you, Ms. Stryker.
thank you.
General, we'll hear from you.
Thank you, Your Honor. Mr. Chief Justice, and may it please the court. The Attorney General's office fully supports the position taken here by Harris County on behalf of the state. I intend to focus primarily on the second argument that they make about the meaning of the word practicable, and in particular why it cannot mean in this statute merely theoretically possible, but has to mean realistic in the real world. That has key implications for the state in at least three respects. One, this statute does not work if the word means anything other than reasonable. Two, that would make a hash out of the law more generally if we start reading practical as meaning possible rather than reasonable. And three, and I think of particular importance in this case, is a contrary reading would be prejudicial to law enforcement, but also to criminal defendants. The incentives created by reading the word to be reasonable, to be possible, is going to create a lot more people into the criminal justice system, which I don't think we want. But before
Say we agree with you about all of
Sure.
that. Okay, given the appropriate review under the one prong without collapsing the two, and given the appropriate definition of
Yes.
practicable, did the state show, as it was its burden, that it could not have brought the charges due to something beyond its control?
Yes, Your Honor, and this is
And what are you focusing on in the testimony or the record that would support that?
sure. But first, just as a table setting, if I may, but I think was going to answer your question, I think also Justice Lehrman's question, like what are the checks to prevent this thing from being abused? There's three. The first is going to be, the first part of the language of the statute is beyond the state's control, which is what we're going to talk about. The second is practicable, which just means reasonable. We do reasonableness all the time. At some point, you exceed reasonableness. But the third, and I think this is one of the key errors in the Court of Appeals decision, is the standard of review. You have a juvenile court who will listen to you, and if the juvenile court makes a factual finding that it was not outside of the state's control, That's
No, that it was outside. the
correct.
state.
If it was outside the state's control, well, I was gonna say, I actually meant the other way. If the trial court says, no, actually, this was not outside of the state's control, well, that means when you try to go up on appeal, that's gonna be, that should prevail. And the state will lose that case if the state were to try to appeal that type of thing. So that's the check. Like, it would be a very dangerous move for a prosecutor to say, you know what, let's just chance it and see what this juvenile court does. Because the juvenile court is gonna listen to the evidence, and if it makes a factual finding adverse to the state, well, the clear error review, which is a very, very hard standard, is going to kick in against the state. Here, what happened, however, was the juvenile court had a hearing, there was a witness, there was an examination, a cross-examination, and a redirect, and made a factual finding. Now,
But what is the evidence
Sure.
that witness gave that supports that factual determination that it was beyond the state's control to proceed in the year and 2 months before J.J.T.
Yes.
turned 18?
So we didn't have the J.J.T's phone number. That did not come up at the initial time, the initial interview of J.J.T. or of Tover. So we didn't have that number that you could figure that out.
Was that because of something beyond the state's control, like they asked for the phone number and people refused to give it to them?
That is not in the record, Your Honor.
That's the part of it that's confusing to me.
Correct, and that's why I think the standard review is so important. There was a hearing. They made the evidence, the state made its evidence. The other side had a chance. The other side did not raise that argument, saying, hey, did you ask for the phone? It's not
But
there.
it's the state's burden to show it was beyond its control.
Correct, and the state put their evidence. There was no response, and the district court, the trial court heard all of this and made a factual finding.
Well, the state said stuff like, because of my heavy caseload and because I prefer to avoid contacting juveniles, I didn't follow up, which wouldn't qualify as beyond the state's control.
Yeah, I'd like to discuss that as well. Obviously, I was not there, so I am just looking at the same record that we're all looking at. I'm also coming from a civil background. So I asked our law enforcement people, like, what's going on? And they said there's a whole bunch of reasons why you wouldn't go back and, after somebody's already denied involvement, they don't immediately go back and keep badgering them again and again. One of which is you don't want to tip them off that they are the suspect. If they know that they are the suspect, they change their behavior. And that would be particularly true for a juvenile who is not maybe as sophisticated about how things go in terms of who they say and what they talk about. If they know that the eyes of the law are looking at them, that will change their behavior. So there's a very good reason why an officer would be hesitant to go back, especially after the juvenile has already denied involvement, to go back again and say, hey, by the way, Tovar said that you might be involved in this. Well, at that point, you've tipped him off and you completely got your ability to do that type of serendipitous investigation just disappears.
Does that qualify as an investigative preference under Moore?
Oh, I don't think so at all, Your Honor. And I'd also, again, my first line is going to say standard of review. All of this evidence could have been presented at the trial court level. They heard the evidence, they made a determination. But no, I don't think so. I don't think that would be an investigative preference. We know that the evidence wasn't there. They asked, they met J.J.T. and he didn't confess. They met Tovar. Tovar had the very self-serving statement. And then the gray key, which is not, I know we have not talked about that yet. It takes time. Maybe in the future we'll be able to do this instantaneously, but as it is now, you can't break a phone other than going through the gray key process. And as Justice Ferris explained in her dissent, which we would urge the court to adopt because we believe it's entirely correct, it's undisputed that that takes the time and they don't challenge it. Once they got that, once they can break that, that's when this thing kind of fell apart. But that didn't happen, the thing being the scheme, it didn't happen until you could break it or he comes forward with the proffer. I realize my time has expired, but
Any other questions?
if I can indulge the court, I'd like to make just one more point, which I think is really important. And that is, the rule here is not, that my friends are advocating for, is not pro-defendant. What we want is our prosecutors and investigators to take the time to do the analysis correctly, because otherwise what's going to happen is you're going to have more people brought into the criminal justice system earlier, including incarceration, And that is, I don't think, the right answer for anybody. I would point the court to the dissent in In Re AM by Justice Kais, where she explains there's nothing in the statute suggests the legislature intended to stop police from doing regular police work, which is the risk that the court faces here. Thank you for letting me go a few minutes over. Thank you, Your Honor.
Thank you, General. We'll hear from the respondents.
May it please the court, Mr. Acosta will present argument for the respondent.
Mr. Chief Justice, may it please the court. My name is Jerry Michael Acosta, and I represent the respondent today in this matter. Generally, when a child in delinquency proceeding turns 18, the juvenile court is limited to either dismissing the case or transferring the case to a criminal district court for criminal proceedings. In this case, the respondent turned 18 on January 15th, 2022. The alleged offense of capital murder took place October 4th, 2020, when the respondent was still 16 years old. The respondent was charged December 10th, 2022, nearly a full year after he turned 18. This is despite the fact that probable cause existed based on the co-actor statement against his penal interest well before the respondent's 18th birthday. Before discussing the lower court's opinion and interpretation and arguments of the petitioner, I would like to point out that there are some very important issues, matters by both parties that are not in contention.
What is your response to the argument that we don't want to encourage the state to file suit too early before they know that they have the evidence that they need?
My response, Your Honor, is that that's not the standard. The burden is on the state to prove by a preponderance of the evidence that for a reason beyond the control of the state, it was not practicable to proceed. In this case.
But isn't it up to them to make that determination as to whether or not they have enough evidence to be able to meet that standard?
Prosecutorial discretion is part of the practicability analysis. But in a situation, like in this situation, in the case before the court, where the state had control over all the evidence, they don't get past the first prong of the statute. The agreements today.
If we're outside of the juvenile context, and this is just a regular murder investigation, would it be unusual or unreasonable for the prosecution to have handled this on the timeline on which it was handled?
Yes, but the
Why?
Because there's not a timeline that exists as it does in juvenile court.
Take the juvenile question out of it. This is just, everybody's 30 years old and this is a murder case. Would it be either unreasonable or unusual or odd or strange to you for a murder investigation to play out along the timeline that this one played out?
What's odd is that in the record, that Deputy Crane, who was the state's only witness in this case, is that he testified that the case would sit on his desk for almost a year with work to be done, and due to his heavy caseload, he just didn't get to it.
Is that unusual or unreasonable for these things to take a couple of years?
It is in juvenile court, and
that's not my question. Just in the adult system, in the regular criminal justice system, is this the speed of this investigation and the charges being brought unusual or unreasonable in your experience?
In my experience, I don't have any experience in the adult criminal world with murders.
Let me ask you, by taking you back to the words of the statute, one significant difference between A and B, the two prongs that we're talking about here, is that B begins with the words after due diligence. It sounds like, now those words are not in A, but it sounds to me like what you're trying to do is import a due diligence requirement into A by saying, well, he had to be doing more. He could, despite his heavy caseload. That doesn't seem, that's not right because those words don't appear in A. So address that. Help me with that.
Okay. Well, the courts have ruled that heavy caseloads, investigative preference, those are not reasons beyond the state's control. In AM, a desire for more evidence is also a reason that's not beyond the state's control. In AM, that was another murder case where the court held a transfer hearing after the 18th birthday of AM for a crime that he committed when he was 16. It was a gang-related murder. The state argued it was not practical to proceed because the delay in prosecution was necessary to gather direct physical evidence to corroborate what law enforcement described as unreliable, self-serving statements of co-actors who were also fellow gang members. That evidence had been established by testimonial evidence, just like in this case. But the court held that the plain language of the statute does not permit the state to investigate at its own pace without regard to statutory deadlines of the juvenile's 18th birthday. And they held that wanting more evidence against the suspect does not qualify as a reason beyond the control of the state.
But if the prosecutor thinks that he doesn't have enough evidence to get a conviction, how is that something that isn't beyond the control of the state?
That's not the standard. The standard is for a reason beyond the control. The state has to establish, it's three prongs to
So it
that.
doesn't have the evidence that the prosecutor thinks that the prosecutor needs. Now, I grant you that if it's just sitting there and he doesn't go for it, that's one thing. But if he doesn't have it, and if the prosecutor's prosecutorial judgment is, I can't proceed until I have something more, I don't see how that isn't something that's beyond the control of the state and that implicates whether it's practicable to proceed.
Well, if we look at the statute and we're looking at plain meaning of words in the statute, you would see that proceed means to do something. It doesn't say that you have to have enough evidence to get a conviction beyond a reasonable doubt. And
So
that-
wouldn't Justice Young's hypothetical fall under B1? Because there it says after due diligence, you don't have probable cause, and then you get later evidence where there is probable cause. So it seems like if you read A to mean the same thing as B1, then the statute, those different parts of the statute have to have a different meaning.
Yes, and this record, there's no evidence of due diligence there in the record. And
Well, and there's also no finding of due diligence because of the weirdness of the way the
Right.
findings were put together, and I understand all that, so we're stuck with A. But what to get back to Justice Huddle's question, what's the difference between the beginning of A for a reason beyond the control of the state and B after due diligence of the state? Those two things need to mean something different. So what have courts told us about what reasons beyond the control of the state are? You've told us what they're not. You've said here are some things that are not reasons beyond the control of the state. But what have courts said about what are reasons beyond the control of the state? What falls under A?
Okay, that would reference the state's cases, probably. In EB, they said in that case, that was a case where it was a murder case where he was charged after he was 18 for a crime that he committed when he was 16. In that case, it wasn't practicable to proceed because the state was waiting on DNA evidence to confirm the identity of the complaining witness.
But why is that different than this case where there is an outstanding pending request to try to get cell phone data that doesn't come in until after much later, much closer to the day the charges are brought? Why wouldn't that be some explanation for the delay that was beyond the control of the state?
The DNA and EB was sent to an outside agency, and they had to wait on that to confirm the identity. The cell phone records, or the cell phone and the gray key, all of that, the record is clear on that was in control of the state.
Yeah, but that doesn't mean that the state can just snap its fingers and get the passcode. It takes a while to do that. Sometimes it can take a year, can't it?
Well, the evidence that's on the record was, again, Deputy Crane's testimony to that issue.
And so it was going through that gray key process, but then after the proffer statement, Tovar gave them the password, so they didn't have to continue that. That's how they got it, but that was barely a month before.
But yes, Your Honor, but that was in their control. They didn't establish it by the preponderance.
What was in their control?
The gray key and the phone, because it came as a result of a proffer, right? And that word proffer itself, it takes two to proffer. A proffer is an agreement for the state to give the defendant or the respondent some type of immunity or some type of deal in exchange for testimony. But it's not a proffer until the state approves it.
Right,
So-
but they didn't get J.J.T's cell phone number until that proffer occurred. right?
There's no evidence of any effort to do so with the
Well,
evidence they had.
exactly. So that's the question. Did there need to be some effort before he turned 18
Yes.
under A?
Yes, because under A, the showings of what is a reason beyond the state of control, let me go back. What Deputy Crane blamed all that on was his heavy caseload, and he had a desire to not interview juveniles until they were in custody. Those are impermissible investigative preferences under the cases.
Right, we know that, but does that poison the well in some way? And if there's also evidence that they're trying to break into the phone and it just takes a long time to do that, is that enough? I mean, it's beyond the control of the state in a literal technological manner to get into that phone any faster, right?
Well, the record is clear that they didn't establish, the state did not establish beyond the preponderance of the evidence. Deputy Crane testified to what it was, and he also testified that I'm not the person to talk to about that. The state did not.
About trying to get into
About
the phone.
trying to get into the phone. The state did not provide anyone from what's called the high-tech crime unit in the Harris County Sheriff's Department where this phone is sent. Deputy Crane testified that he gave it to the high-tech crime unit and that he knows that it's plugged in, but there was no evidence that it was ever plugged in. There was no evidence of any of the policy or procedure presented that, you know, if you plug into a phone, how long does it stay there? How many
But that's all
folks?
Tovar's phone, and I think they point out that, and it doesn't seem as though that they even relied on Tovar's phone at the end of the day to bring these charges. They got J.J.T's cell phone number from Tovar and used his cell phone number then to get records, geolocation records. And all that happened about a month, they got J.J.T's cell phone number about a month before J.J.T turned 18. So I think their argument is that we couldn't go further until we had the number. We didn't get the number until a month before he turned 18, you know.
Well, they had plenty of evidence to go approach JT, and the lower court held that they had probable cause against JJT to go get a search warrant or something, to do something in regards to JJT's phone.
So COVID was going on at this time, and that was part of the testimony, that the things were backed up and weren't happening on schedule because of that. Why isn't that legally sufficient evidence for finding that, to sort of excuse the delay in getting the cell phone records?
Well, because as the court found in Moore, heavy caseloads are not a reasonable, or not a reason beyond the state's control.
Well, the COVID lockdowns and all the disruption that caused, what was beyond the state's control, you would say, right? And that's not maybe distinguishable from just the run-of-the-mill heavy caseload.
But that led to a heavy caseload, which is not, under the cases, a reason beyond the state's control. The lower
You
court,
said the trial court found that there was probable cause to get a search warrant for the phone, but was
not
that?
the trial court, Your Honor. The lower court, in their opinion, said that there was probable cause, and that. But go ahead and.
No, that's okay.
Okay, and the lower court did not make probable cause dispositive in this case. Instead, they found the court abused its discretion in this particular case, and under these particular circumstances.
Because the Court of Appeals conflated the two separate prongs, did it ever really undertake the analysis that we're discussing this morning about whether or not the evidence is sufficient to demonstrate that the reasons for the delay were beyond the state's control?
The lower court's opinion does not do that.
Does not go into that at all.
It gives great weight to the existence of probable cause. It does not convolute. It does not replace probable cause. It does not make probable cause dispositive. It does not make probable cause positive. What the lower court said that under these facts, where you have heavy caseloads, unnecessary delays, a desire for additional evidence, which the court said in AM, its own precedent, that was not a reason beyond the state's control. That if you looked at the fact that they had probable cause too, they couldn't they couldn't disregard or turn a blind eye to the fact that probable cause existed in this case. When you have all this other stuff going on, we have Deputy Crane testifying that his case file would sit on his desk for months at a time, all these unnecessary delays, that in this case, in this particular case, under these particular circumstances, where there was not a reason beyond the state's control, probable cause was given great weight. Not that what the state is asking you to do requires mental gymnastics. Like that's not what the court did. They didn't combine, graft. That's not what happened.
But would your proposed rule be that if law enforcement has probable cause, they must charge?
That's not this case. I mean, that's not what I'm saying. And I don't think that the respondent is saying that there's a general bright line rule. The rule is if for a reason beyond the state's control it was not practical to proceed, that's the rule.
Do you agree with the point that was made that the rule that you're advocating for seems to give the state an incentive to charge people as soon as it can, whereas letting the investigation play out and learning more might avoid that in some cases?
Well, the rule, again, is that the purpose of the statute is to limit prosecution of an adult for an act that he committed as a juvenile. It's a limiting rule. So to charge someone after they're 18, that's the exception. The state has to run through and has to prove, it's their burden to prove that they couldn't proceed because of a reason beyond their control.
Are the punishments different for capital murder committed as a juvenile with a determinate sentence?
Yes.
Versus capital murder when charged as an adult, which is life without parole or the death penalty?
Are you talking about
What's the sentence for a juvenile?
under a determinate sentence?
Who's adjudicated delinquent based on capital murder?
It's up to 40 years on a capital
Up to 40
murder.
years versus as an adult, life without parole for felony capital murder.
Correct.
Or the death penalty.
Not the death penalty.
Not the death
Death
penalty?
doesn't apply in juvenile cases.
Because as a matter of constitutional law, they can't, even trying him at J.J.T. as an adult, they cannot seek the death penalty.
Correct.
So it would be no sentencing determination whatsoever. If he's found guilty, it's life without parole.
Yes, correct. And further, Your Honor, in closing, I would say that the Court of Appeals did not find the existence of probable cause dispositive in this case, that they did give probable cause great weight. They didn't graft or make probable cause dispositive, but that they did, under this specific case, under these specific circumstances, they could not disregard that probable cause existed. The petition at bar refuses to acknowledge that the Court of Appeals held that the delay in this case was at the fault of the state and not for reasons beyond the control of the state, and that the trial court abused its discretion in its decision to waive jurisdiction because it did not represent a reasonably principled application to the legislative criteria of 5402 J4A. And to close, the respondent would pray that this court affirm the lower court's opinion that the trial court abused its discretion by finding by a preponderance of the evidence that it was not practicable to proceed before the 18th birthday of the juvenile respondent, and that was for a reason beyond their control. In the alternative, if the court reverses the lower court's opinion, we would ask that this court remand it back to the lower court for a factual sufficiency analysis because that was not done by the state.
Any other questions?
By the court.
Thank you, Mr. Acosta. Ms. Strecker, you have 5 minutes.
Thank you, Mr. Chief Justice. I know that I exceeded my time on the first go-round, so I'll be as brief as possible with my rebuttal here.
We won't hold that against you.
Oh, thank you, sir.
That was our fault.
First, I'd like to maybe list out, in response to some questions by the court here today, some reasons beyond the state's control. First and foremost, we have J.J.T's date on the offense, when he committed the offense here. And that was 16 years, 8 months, and 20 days. So we're already very close to his 18th birthday by the time the offense is committed. Second of all, we have J.J.T's denial of involvement, which he carried through. So when the police initially approached him, he completely disclaimed any involvement, any knowledge about this case. And there was some discussion about, well, why didn't Crane re-interview him? And first of all, I would submit that there's not an obligation upon the police to re-interview when a suspect's already spoken to the police. And at some point, you have to look at the coercive nature of the police consistently reapproaching a juvenile and any statement that they get being of a coerced nature if the police badger him over and over to try to get him to speak again. Third, you have Tovar's statements, which, as I've discussed, start off as a completely blame-shifting statement and then morphs into a blame-sharing statement by the time of his December proffer, which is what enables the state at that point to have probable cause to go forward with an arrest warrant for J.J.T. That dovetails into the fourth consideration, which is beyond the state's control, which is the date and timing of that proffer meeting. And that was all within Tovar's hands. Tovar was already in custody and at that point would have a Sixth Amendment right to not be reapproached by the police in furtherance of an additional statement, absent his affirmative actions to reinitiate contact himself.
So that all sounds like a great case under B1. After due diligence, you didn't have probable cause until you got new evidence, actually right before the 18th birthday of the person, and then more new evidence from the search warrant and the geolocation after the 18th birthday. So aren't we harming the statute if we try to shoehorn those B1 facts into A?
I think there's considerable overlap between those statutes. And I think, given the circumstances of this case, makes it a prime example of illustrating that overlap. When the legislature crafted subsection A, subsection B was actually the original provision, if you look at the statutory history of this. And
which all the more reason that A should cover something different.
Well, I think it can cover something different.
Can you give me some examples from other cases? What have courts held as a reason beyond the control of the state?
Well, EB, which I cite in my brief and opposing counsel discussed here, reasons beyond the control of the state in that instance were the juvenile respondent's, his lying to police, his non-cooperation throughout the police's efforts to investigate, the pendency of forensic analysis, DNA, and other forensic testing that they were waiting for in those cases. Justice Bland mentioned that a common example for reasons beyond the state's control might be a delayed outcry in the circumstances where a sexual assault is at issue. So either the delay or the outcry doesn't come until after the respondent has turned 18 or so close before the respondent's 18th birthday that it's then not practicable for the state to proceed.
So that's helpful, but it just seems like the types of things you were describing are more like B1. So rather than trying to fit something that maybe doesn't quite fit A, why shouldn't we just send it back for the court to do another finding under B1 if that's what it intended to do, instead of this Frankenstein finding that it made?
This court certainly could do that. I don't think it's necessary because I think the way that A is phrased was intended by the legislature to offer a broad sort of catch-all. And that works in circumstances like in this case where there's maybe a gray area as to when and if probable cause existed. So if you're not sure...
But probable cause is expressly addressed in B1.
Yes, Your Honor, but because there may be a question as to whether probable cause exists or not, A then operates as a catch-all, a much broader basis for the state to seek transfer and obtain transfer.
If probable cause does exist?
If probable cause does exist, yet for reasons beyond the state's control, it remains impracticable for the state to proceed.
But your position is that probable cause did not exist.
I agree that probable cause existed at some point. I disagree as to when probable cause existed.
I thought your position was it existed a month before the 18th birthday.
That is my position. And because it existed at that point so close in time to the respondent's 18th birthday, it was then not practicable for the state to proceed in juvenile court at that time. That's the state's position.
B1 requires that the new evidence be found after the 18th birthday.
Yes.
That's a distinction between A and B1 that seems pretty obvious.
Yes. Yes, and in this instance, the geoplotting data was not actually attained until after his 18th birthday.
Right. New evidence has been found since the 18th birthday, and it was in this case.
Correct.
But other things happened before the 18th birthday. And we're right around this point, but
Yes.
B1 is imposing the due diligence requirement, which because of this order, we just have to assume the state didn't exercise due diligence, but that's not a requirement of A.
Correct.
So is A in some sense harder to satisfy, but it covers more space? Everything maybe in B is perhaps easier because due diligence is shown, but there are specific things, only specific things that B will allow.
I wouldn't contend that A is harder to satisfy, but I would agree that it is much broader. And I think it was crafted that way on purpose to avoid cases such as this where, again, there may be a gray area or some dispute. Reasonable minds might differ as to when and if probable cause exists. And when that happens, A operates as that catch-all, as I said, to allow transfer in justifiable cases where the state establishes by a preponderance of the evidence that it was not practicable to proceed. Just one last point before I end, if I may, Your Honor. I think, to touch on Mr. Nielsen's argument, the rule that the respondent proposes here will result in basically turning the criminal justice system on its head. Instead of encouraging the state to exercise due diligence and to conduct thorough investigations, the practical effect of this will be that the state will have to pursue charges from the moment anybody might perceive that probable cause exists.
Or not. I mean, the prosecutor can elect in his or her discretion not to.
But then in a case as egregious as a capital murder, then the state would forever lose the ability to pursue justice.
That's what prosecutorial discretion is, right?
Sure, but if the option is don't seek justice on behalf of the citizens and the victim in the case, then the state is going to file those charges whether we have the evidence that we need or not. And then this case, it wasn't a matter of desire for more evidence. It was a need for more evidence because of the accomplice witness rule, which is in both the Code of Criminal Procedure and the Juvenile Justice
The
Code.
consequences to the defendant are quite extreme. The defendant is only subject to a maximum of a 40-year determinate sentence with the possibility of parole as a juvenile. The defendant will automatically get life without parole when tried as an adult.
Actually, a juvenile offender, if they commit a capital murder as a juvenile, is life without parole is not a possibility. The Supreme Court has held that, but yes, they could still have life with the possibility of parole. So yes, I don't disagree.
For a juvenile, they can get the possibility of parole.
Yes, ma'am.
Okay. So it's not as much of a difference then.
Well, 40 years versus potentially life, that is certainly a more onerous punishment that they would be subject to. But what about the instance of an innocent juvenile? If the state rushes forward with a premature prosecution, and so in hindsight, we see here that the state did eventually obtain corroborating evidence, but what if that never happens? How long do we detain a juvenile awaiting even juvenile proceedings? At what point do their speedy trial rights come into play? How long do we hold them waiting for this corroborating evidence that we have to have before we can proceed in a case like this?
Those are all great policy questions, but it seems like the legislature's already balanced them in this statute.
Perhaps. Yes, sir.
Any other questions?
Thank you. I'll ask that this court reverse. Thank you so much.
Thank you, Ms. Stryker. The case is submitted and the court will take another brief recess.